Hello everyone, this is Harry with the Law Office of HK Gandhi. We're located here on the beautiful shores of Lake Superior in Marquette, Michigan. We work with companies, families, and professionals on all kinds of immigration situations. I'm proud to be partnered with Lawfully to bring you this week's Q&A session, so let's get started. Yes. Because you say that you were married to a citizen, the overstay will not be an issue. It will be automatically waived at the interview. So you just go ahead and file the I-485 and prepare for the interview. It should not be any issue. So you can file two H-1B applications simultaneously. You can only have one primary. If you're working for both of these companies concurrently, then you can go ahead and file concurrent applications. But you stated that you only want to work with one of them. I would not file two applications. I would pick one employer and go ahead and initiate the transfer with that employer. So this is an interesting question. You do not have to use the Greencard EAD. The Conan memo speaks specifically to this, and it states that someone who is on H-1B who travels on AP, perhaps to avoid stamping, and then they re-enter on AP, they will be deemed to maintain their H-1B status if their job parameters remain the same. So as long as they're working in the same job, same hours, same location, if everything remains the same, then their intent is to maintain H-1B status, and therefore H-1B status is valid. You do not need the Greencard EAD in that situation. You may need to file an extension to terminate the underlying advance parolee status as well, but you are on H-1B status, so you can go ahead and work. Well, because you're on H-1B status, you can travel at any time. H-1B and L-1 holders maintain their dual intent status, and as such can travel even while the 485 is pending. Yes, under two conditions. Number one, they must now be a household member with the petitioner, and number two, the source of income that they are claiming that supports them financially, that source must continue. So if it's a job, you need to get an offer letter saying that your job will continue. If it's an asset, you need to show that that investment is going to continue even after you've immigrated, and that income is going to keep coming in. If you can show that, then yes, they can go ahead and use their income. This is common with H-1B applicants who are now applying for adjustment of status. They can use the current job they have with their spouse and just get an offer letter. It's very common. Yes. Now, USCIS prefers and suggests that you interfile, but there's nothing illegal and nothing that prevents you from filing an I-485. And we at our office actually prefer refiling. We've noticed that when we refile a case, it's gone to the National Benefits Center, and we're getting approvals between 6 to 8 months on green card applications. So we prefer to refile. The data suggests refiling is quicker, but USCIS prefers that you interfile and recommends that you do. So is it advisable? Some attorneys are conservative and then some are liberal. I prefer that you do not travel while the I-485 is pending under most circumstances, even if you have advanced parole. However, you can legally travel, and many lawyers will say that you can travel freely and it shouldn't be an issue. So yes, legally you can travel even while your K-1 is pending, or your marriage-based green card is pending from your K-1, but please be back in time for your interview. So this question is regarding to the AC-21 portability. No, you cannot change your job before the 180 days. If you want to take your green card with you, as far as AC-21 portability is concerned, then you will need to wait at least 180 days. When you interfile from EB3 to EB2, you are basically telling the government you want them to use your underlying I-485 with a new basis, the EB2 basis from the I-140 that was previously approved. When you do this, you're basically resetting the portability clock, so you will have to wait 180 days. So yes, you can change your employer. However, there are a few things you need to keep in mind. Number one, the job needs to be same or in the similar field. So direct promotions are okay. If you go from an individual role to a manager, that's okay. But you need to be in the same field. So if you're a software developer, you cannot now become a doctor and apply for using a 485J. Number two, your new employer needs to provide a bona fide offer. They're basically taking over the green card application, so they will need to provide a I-485J. You will need to file this. Now you can file this affirmatively. You can wait for an RFE, or if you're getting scheduled to an interview, you bring it to the interview. But your new employer will need to provide a 485J. Those are your biggest requirements. So that is incorrect. You cannot leave the country before the travel document, the advance parole, is approved. If you leave before that, you will be deemed to have abandoned your I-485, your green card application. You have to wait till after. Once you have it, you can go ahead and leave and return on advance parole, but before that you cannot travel. You cannot apply for it and leave. Thank you to everyone who submitted a question for this Q&A. I apologize if I did not get to yours. If you still have questions or want my opinion on something, please book a consultation with me through the Lawfully app. And thank you again, Lawfully, for being a proud supporter of the immigrant community. And please remember, immigration process is going slow right now due to COVID delays. Let's all be patient and we will get through this. Thank you.